Welcome to the Pregnancy Help Podcast. I'm Christine Grimmett with Danielle White, General Counsel at Heartbeat International. And we are so honored to have Peter Breen, Executive Vice President and Head of Litigation at the Thomas More Society, joining us for this episode. And the Thomas More Society has been such a strong defender of the pro-life movement. So we're going to get to know the work that they're doing and the people involved on the legal front in this episode. And we've been taking listeners along for the ride here on the Pregnancy Help Podcast as Heartbeat and others within Pregnancy Help are involved in various legal cases across our nation. So I want to remind our listeners that another way to stay updated is by subscribing to pregnancyhelpnews.com and subscribing to this podcast for the monthly Pregnancy Help News Brief episodes. Thank you, Danielle and Peter, for being here. I'm excited to learn, Peter, more of your story and more of Thomas More Society. So I'll turn things over to you guys.
Thanks for having us, Christine. And Peter, thanks again for being here.
Great to be with you guys. Thank you.
Yeah, so I actually met Peter when I was a fledgling attorney. I had the opportunity to be a summer associate with the Thomas More Society back after my second year of law school. And I got to see how varied and wide pro-life issues really are. And I learned a lot in that role. And so I'm grateful that I got to know you, Peter, and then had the opportunity to reach out to you when we experienced some targeting from the California Attorney General.
Sure. I mean, and it was a pleasure and an honor to have you as one of our summer associates. And, you know, just dealing with the issues facing pregnancy centers, that for me is an issue of particular concern. My wife had been the director of the pro-life office for the Archdiocese of Chicago under the late Francis Cardinal George. And so she got me in. And one of the things I did early in my time as a pro-life, kind of in full-time pro-life ministry, I started several pregnancy centers. And so Heartbeat International, I mean, of course, I had on speed dial. And, Peggy Hartshorn was, the president at the time. And just I probably talked her ear off every time I would get a chance to talk with her or any of the great team there to help us get off the ground and get going with our pregnancy centers. Going into pro-life legal work full time, I had that background really of pregnancy center work and really kind of the blocking and tackling of trying to make these small ministries and now much larger ministries, seeing some wonderfully successful pregnancy centers, but seeing that at various stages and being able to hopefully keep everybody legally on the level and navigate some of these new challenges that have been facing us just in these last few years, especially in the post-Dobbs period.
Yeah, absolutely. It's really a blessing to have somebody who knows centers that's doing the work that you're doing now that you're in this position doing litigation. So we heard a little bit about how you got started with pregnancy centers. How did you then move into working with Thomas More Society?
Well, I was running two centers. We were pretty successful there in DuPage County, which is the county it's just west of the city of Chicago, about 1 million people. And we had got news that Planned Parenthood was opening a 22,000 square foot facility just a few miles from my centers. And, they did it under the cover of darkness. They used fake names, shell companies, totally just pulled the wool over everyone's eyes in the community. And so I, as an attorney, I was a trained attorney, but was doing, pro-life work full time at that point. I volunteered on the legal effort, which was led then by Tom Brecka, who is the founder of the Thomas More Society, volunteered to help out, and including reviewing the entire zoning code of the city of Aurora, Illinois. So it was, 250 pages of fine print. But my background was in electrical engineering. So I was actually a registered patent attorney. So I knew how to read a lot of detailed stuff. Didn't have a problem with that. And I went through and found a provision that the Chicago Tribune would later call the silver bullet, to take out this massive abortion facility. And again, at the time, it was the largest abortion facility in the Western Hemisphere, of the world. So monstrous thing. And so, we went through an administrative process, and of course, we're unsuccessful because the elected officials at the city level were all good Democrats, and of course, they fall on the line when Planned Parenthood comes to call. But at the end of that process, I said, hey, I got to go back to running my pregnancy centers. This legal thing, this is taking way too much time. And well, at that point, Tom Brecka said, I need you to come to work for me. And so one thing led to another, and all of a sudden I'm working for Thomas More Society. And within a year, I was both, staff counsel, but then also serving as executive director to try to manage some of the back office, and that was back 2007, 2008. So we're now talking almost 17 years ago that I started up with the team, and now I'm the second longest tenured attorney, third longest tenured staff member. But I started out carrying Tom's briefcase, going to hearings, and training with Tom Brecka was great because we'd go into a hearing and you'd walk through the door to the courtroom and he'd turn to me and go, well, do you want to take this one? Just it's like toss you in the pool, see what happens, and and that's how I was trained early on, and then have been able to do a lot of great legal work since then, and served in the Illinois House of Representatives, and did all the other things. And now just at the beginning of 2023, so we're now coming up on 2 years, Tom restructured the organization and put me at the head of litigation. So we've got our whole legal team, which is a lot of it is dedicated to pregnancy center defense, along with defending the pro-life movement and religious liberty movements and others, and that. We're now up to about 15 staff attorneys and maybe another 30 special counsel around the country. So that's our team, and we've got over 100 matters pending at any one time. So it keeps us very, very busy. But we're just we're doing. I will say this: we do have a wide variety of work. We are up against the best attorneys in the country. The other side has a bunch of Harvard and Yale and big firm people, and so we have to be totally on our toes and doing the best quality legal work possible. And we're able to, we win a lot of cases. So frankly, even when we're not successful, because sometimes look, facts may be against you, the law may be against you, the judge may be against you. But even if we're not successful, boy, the other side's got to spend a lot of time and money trying to keep us, at bay. So that's where it is. That's kind of my background then from Pregnancy Center on.
Yeah. You guys are working on a lot of important things. What was it about the California AG case and the New York AG case that Heartbeat's involved in that spoke to you? Like, why did you guys want to take that one on?
Sure. And we had seen this coming. So the attack from the other side, they tried a few years back the posting requirements. Well, they wanted you to put a big sign in your center talking about how terrible you were and how you're not a complete reproductive health care facility and all this. I mean, just utter hooey. Supreme Court struck that down. Well, the next round was the attack using the deceptive practices, false advertising laws. And the reason the other side tried that is because it's a little more flexible. There's a little more play in those laws. And of course, from a First Amendment perspective, you sit there and go, well, of course, fraudulent speech isn't protected. If I buy a Coca-Cola and it says it's 16 ounces and it turns out it's 15 ounces, well, then I should be able to sue somebody. They've defrauded me and millions of others. But that whole commercial context doesn't fit when you're talking about a significant issue of public debate like abortion. And so we had seen, these efforts were popping up around the country, and we got involved intensely in a law that was passed in Illinois in 2023, early 2023. It started up where they specifically were targeting pregnancy centers using these false advertising, deceptive practices laws, saying that pregnancy centers were misstating the risks of abortion. So we were overstating the risks of abortion on our side, that we were concealing an alleged fact that that childbirth is much more deadly than a surgical abortion, which is utter hooey. We know that. But the Illinois General Assembly, in which I used to serve, was declaring that as the law of the state of Illinois. So it was a horrible, horrible thing. And we were able to go into court, and a couple other states in the Northeast had passed laws like this. But what we were able to do against Illinois was we marshaled the entire pro-life community. We had a great legislative response. We had the right questions asked in the committee by our very, very sharp Republican legislators. And I don't want to be partisan, they're just those are the pro-lifers in Illinois. We were able to, again, the movement was in. We had the right FOIA requests in. We did FOIA requests that showed the Attorney General had not had a single complaint against a pregnancy center for deceptive practices in the last 10 years. And they instead, their staffer, whom I know well, she had gone in and said, oh, we've had scores of reports and complaints. Well, the truth of the matter was, no, they had not. And so we were able to put all of that together in a beautiful package, looking for an emergency injunction when the thing was finally signed. And within a week, we had a preliminary injunction, that the other side, they made a big deal. Oh, they were like, oh, we're going to challenge it and this, that, and the other. Well, when push came to shove, and when it came time to put evidence in front of a court, in front of a judge, they backed down. And so we were able to beat them permanently on that case. They accepted a permanent injunction against the state of Illinois enforcing the law, and we got a $155,000 check out of it. So just for our trouble. So that was
In addition to that, you got some great language in that opinion. Do you want to share a little bit about what the judge had to say about the actions of Illinois?
Let's just say, he actually, he was pretty well. And so this judge was looking at this as, hey, this is the chief law enforcement officer of the state of Illinois. And then the court raised that point. And actually, because we were on top of this from minute one. We were able to lay this factual foundation. If we didn't have the FOIA requests and then didn't have the really good questions in the committee, which were just carefully targeted to make sure that the right things were done, the floor debate was incredible. We've got a great floor leader on the House side who is a former prosecutor, I think at this point. But he was asking really good, sharp questions, and even just the little factor of getting on the record that the Attorney General came down to the House floor during the debate and sat next to the chief sponsor on the Democratic side. So as he's asking the chief sponsor all these questions, well, would it be a violation of this new law to say that abortion is a sin? So think about that. Purely religious statement, not something that the government has any business getting in the middle of. And the chief sponsor, with the Attorney General of the state sitting next to her, says, well, it'd be a facts and circumstances determination. So at that point, when you've got that, and then afterward, after the governor signed the bill, the Attorney General stands up at the headquarters of Planned Parenthood of Illinois in front of a big Planned Parenthood banner talking about how great this new law is that targets Planned Parenthood's political opponents. And so look, all of that together, we were able to really weave that together into a good legal package, get it done. But what we were then able to elicit, because when you do that job correctly, it's one thing, and the judge could have just looked at the law and said, well, you guys are right. But because we had the facts and we had all of these other points that we were able to bring together, well, you get a better judicial decision out of that because you put more facts and more law in front of the court. And so the court held, he quoted Justice, the late Justice Scalia, or Justice Scalia used to say, he says, I wish I had a button that said stupid but constitutional. The idea being legislators, they will pass. Again, I've been there, so you'll pass some really dumb bills into law because somebody somewhere got a bug in their bonnet about something and they wanted to do it. So fine. And so the judge said, in this case, this bill is both stupid and unconstitutional. So it was kind of he made a play on the words there. And in part because he was able to find both the content-based. So in other words, we've been making we have been vigorously arguing something that I don't know that others have been arguing up to this point, which is, hey, if you're a government and you are trying to stop speech about abortion, and we're talking, anything that's, controverted speech about abortion, the government has no competency to declare what is true or false in that very, tumultuous arena. And we've been arguing that vigorously to every court that will listen to us. And that point, we were able to win the day on that. And so that was a very important precedent that we got in place because the state of Illinois and the Attorney General of Illinois decided to get out over their skis and come after pregnancy centers. So we've been using that case. In fact, you see it. It's cited in many of our other cases since then, these last 2 years. So that decision has continued to redound. I guess it's actually only been a year and change. But so that then informed the way we looked at the case when Rob Bonta, out of nowhere, comes and sues Heartbeat and Real Options. So he sued Real Options, which is in Northern California, which is they sued us in Oakland. So when you're looking at jurisdictions that are a little bit where the jury pool, let's say, is hostile to pro-life, Northern California, I mean, it's tough to find a spot in the country. I mean, maybe the actual District of Columbia might be worse. But even New York's better in most places. So
Yeah, I was
like
just
that
about
is,
to ask how Manhattan stacks up because we get
yeah, not
Harvey was
good,
trying to,
not good.
almost got dragged into Manhattan too, which we'll get to in a moment. But
Right, right. But I mean, think, San Francisco, Oakland, Berkeley, that area. I mean, my goodness, you're walking into that's a buzzsaw. And so with that, we were very interested when that came down, and we saw it as just it is another piece. Now Bonta and his crew were going after abortion pill reversal, which is obviously, I mean, that is an incredibly important ministry of the nation's pregnancy centers, an important ministry that Heartbeat leads. And that is something that, so we really were interested because we wanted to jump into action to try to protect that. But as well, because of the way we'd had this experience in litigation and been successful, said, look, we are not just going to make bare legal arguments. We want to put the entire chemical abortion regimen on trial. I mean, if they're going to force us into court, well, let's get the word out there about what abortion pill reversal is, but certainly why is it necessary and what does it do in relation to the entire chemical abortion regimen, which is damaging to women. It, I mean, obviously kills the child, but the whole process, I mean, it's just devastatingly dangerous. I mean, we would not allow that process to proceed with any other prescription medication in this country. Except when we're dealing with something as important and fraught with public dispute as abortion, we'll just just embrace it and throw it at everybody. And so that that together it was a big deal. And of course, I mean, they're attacking Heartbeat, so they're going after the largest national pregnancy center association. They're trying to hit you for every single call that was made to the hotline, every time someone bounced on the website. So it's millions of dollars. It's ruinous, fines and what have you, injunctions that would be embarrassing. And, and when we go out to New York, they very specifically wanted, compliance reviews and things like this. So all of that together, we just said, look, we have the team to do it. We have the obviously the love of the pregnancy center movement and ministry. And so that's really the way, why we jumped in there. And I'll tell you too, so Bonta, he just sued. And of course, on the day that he sued, he hadn't even filed the complaint. So I know, Danielle, I mean, you guys are getting media requests and you're going, what did he just sue us with? And we're going, where's the complaint? We're looking on the filing, on the filing website, and we're going, it's not there. So that was, I mean, look, it was a media hit at first. But we, again, look at it as they have come after something that is well established. There are thousands of babies alive today because of APR, abortion pill reversal. And so we're very hopeful that we're going to be able to put them on trial instead of the reverse. Let them be like the proverbial dog that caught the bumper of the car. We're the car on that one, and we're going to win that fight. So that's the way we look at it there.
Yeah, and there's something really interesting about when you talk about abortion pill reversal, it's always so odd to me that those who are in favor of women's choices seem to be so opposed to her exercising this choice. Could you speak a little bit about the California Constitution and some of the provisions in there and what that means for APR in the case?
Right. And what's happened in some of these blue states, and you see this, I mean, whether it's, just in the last few years, especially post-Dobbs, our practice has really been focused on New York, California, and Illinois, the top three abortion states. You're seeing it in these states and others in the Northeast and the Northwest. They're bringing laws into effect, and they have constitutional provisions they interpret in this way that all reproductive health pretty much is put at the highest level of constitutional protection. So it's above free speech. It's above every other right that we hold dear. And well, included in that is, and necessarily, is the right to have your child. In other words, to carry your child to term. And if anything, that the U.S. Constitution has been held to protect the right to bear your child, to have that child, even though abortion is no longer part of the U.S. Constitution, thankfully. So when you start looking at these laws they've passed to put that into statute, protect it, give you a full immunity if you are helping someone exercise a reproductive choice. Well, we've asserted in the California lawsuit and in the New York lawsuit. I mean, if we ever get off first base there, but we've asserted in the California lawsuit very strongly, hey, we're assisting women in making a reproductive health decision. And it's the absurdity of the abortion issue, where if the baby's wanted, well, all of a sudden this is a full human being with all rights available, and if you do anything to harm that woman or that baby, you can be sued civilly, you can be prosecuted criminally, which is appropriate. I mean, it should be. That's good. That's what the law should do. But the instant that you don't want the baby, well, all of a sudden it's medical waste. This little beautiful child, which if that mom wanted the baby, you would be convicted of murder in many states if you shot the baby. Well, if she actually doesn't want the baby, then all of a sudden it's medical waste and no issues. Medical malpractice laws just get, kind of tossed out. Everything else is, I mean, again, we can do these Wild West procedures, the chemical abortion regimen, and the like. So that to me is kind of the place that we're pushing on. So every time the other side is engaged in these really logical inconsistencies, we push on them. We just if they're going to bring us into court and they're going to put us through all of this, we are going to pound them back. And it's something that, I mean, we learned early on at Thomas More, and Tom Brecka will tell you about this back. The firm was started to defend Joe Scheidler and national sidewalk advocacy, pro-life advocacy across the country. In a massive, they had filed a racketeering lawsuit against Joe Scheidler and the Pro-Life Action League and others by the National Organization for Women. We beat them, but Tom told me, he early on learned, he was a successful business lawyer. The media would call, he'd say, well, we'll do our litigating in court. We'll do our speaking in court. Well, all of a sudden then, the New York Times would report, extended quote from the abortion lawyer and no comment from Tom. So he said, that's nuts. We're not going to do this. And we've since then, we realize when you use the media correctly, you deploy it right, and you tell your story, you can, I mean, whether you say it's turning lemons into lemonade or again, helping to put the other side on trial when they're doing something abusive to us, we're not going to let them out easy. And so that, whether it was, I mean, most recently you've got, the win in Illinois. I mean, we utterly smashed them in the media. We took every opportunity, we pounded on them. Going back to Mark Houck, who was the Pennsylvania dad that was a sidewalk counselor that got, 25 federal agents showed up at his house. We utterly pounded the drum so that when we finally beat the US DOJ, and actually, frankly, it would have been horribly embarrassing had we lost. We could have lost that case. It was, some good lawyering we were able to do there. But because we were so vigorous in pursuing the media, a felony criminal defense, normally you sit there and go, oh, we don't want to say anything. We want to be quiet. Blah, blah, blah. No, we went after it. And so after that, when we did get the not guilty verdict, then members of Congress just piled on. Every time Merrick Garland would come in front of the Congress, they'd ask him about Mark Houck every time. Mm-hmm. And so that was, we use these opportunities to drive our narrative and to make the other side pay for harassing us in this way. So we had our California lawsuit. I think we're going to go to New York. I do want to talk about some of the lessons we learned. And in California, obviously we had no opportunity to go to court first. We couldn't jump in. We couldn't attack because we didn't, we found out about it from a media call. But in New York, that was another example, I think, kind of like Illinois, where when the pro-life movement is unified, where we can come together, we get our activists, our organizations, and our lawyers together, thinking together, working together, we can really, it's beautiful to watch. And so in New York, thank goodness, New York law requires a 5-day notice of intention to sue before the AG can sue for a deceptive practices law violation. And other states have this too, where the whole point is supposed to be the AG is supposed to be seeking compliance. So if you're saying something you're not supposed to be saying, the AG can come and talk to you and you can fix it. And, if everyone was in good faith, that's fine. But here, where it's just harassment, we said, well, okay. We figured she was going to sue our clients. So she issued these notices to 12 different centers across the state, to Heartbeat in Ohio. But I mean, and we're talking in the entire state of New York, from Queens all the way up to the Adirondacks, over to Niagara Falls. I mean, everywhere. And just the effort of being able to then, within those 5 days, getting 12 different small to mid-sized pro-life organizations plus Heartbeat, get everybody on the same page with 12 different boards of directors, plus, Heartbeat. Obviously, we're already representing Heartbeat in California, so you guys knew the drill. But we had a couple clients in New York that we'd been working with, and they got these notices. But then getting everybody on the same page, getting permission for everybody, getting the buy-in from everybody to the point where we were able to bring everybody together in one lawsuit. And we said, hey, if the attorney general is able to choose, she's going to sue us in a hostile jurisdiction. Something she's going to say, well, she's going to drive up the cost of litigation against us. She's going to hurt us. She's going to go to a place where she perceives she's going to get a friendlier reception in court. And we said, that's not right. That's gamesmanship. That's not an appropriate use of the legal process. And, your chief law enforcement officer of the state should be treating everyone equally. Well, this AG doesn't. Letitia James is one of the worst attorneys general in the history of the country. Bar none. Well, so we were able to get together and we sued in Rochester, which is kind of in upstate New York, right? It's centrally located well enough, easy to get in and out of. And we were able to get that done before she went to court on us. And what happened? 6 days later, she sues us in Manhattan, where literally none of these pregnancy centers or Heartbeat has an office. They don't have, it's like you sued us in the one place where we're not. And so that was, it really showed it's also the most expensive place to litigate in the country and one of the most expensive to litigate in the world. And we're talking nonprofits that some are as small as $50,000 of revenue a year. Just the hotel nights, much less getting everybody in and out and all of the trouble of litigating in New York City. It was crazy. So we were able, though, to jump in front and to get a centrally located venue that everybody, was when you're suing these pregnancy centers from across the state, well, Rochester, everybody could get to, Manhattan, long drives. And it was very difficult for folks in upstate New York, which is most of our clients. So we were able to do that. And my goodness, you would not believe the reaction of the attorney general staff. They were furious, and they're screaming to the judges. They're desperately trying to get in front of they had a different judge in Manhattan. They're trying to get him to overrule the judge in Rochester. And it was the sort of thing you just don't see this in the law. They were breaking what I would say all of the norms, and it was really horribly bad faith to even just try to sue us in Manhattan in the first place, but then to try to reverse a judge in another jurisdiction who ordered, hey, this thing's going to be consolidated. The matter should be heard here. And we, because we were quick, we were first to file. And so that is a big, big deal. Going back to the English common law system, first filed, you usually are going to win. And so we were able to get that done. And now that matter's up on appeal. The attorney general appealed the consolidation order, even though there's no basis for it. So that's on hold right now. So we fought her to a standstill there.
Yeah, and I just wanted to jump in and really applaud your team, because I was watching emails going, to say that you were working around the clock is no exaggeration. It was through the night, it was through the weekend to be able to pull together. Those who are listening who have experience in pregnancy center boards, that it can sometimes be an adventure to get everybody marching in the same direction. Now take that and multiply it by 12 and work in lawyers who need data and information and they need a physical signature. It was really just unbelievably impressive what your team was able to pull off in such a short period of time.
Well, thank you, Danielle. And it was funny. One of our senior litigators, he's been at this for decades, and he said he just kind of marveling at the effort. He said, "We big firmed them." Because this is a New York Attorney General, second only to California Attorney General in terms of staffing and money and all. They have outside funded reproductive rights fellows. So attorneys that are specifically there to harass our pregnancy centers. And we were able to put them on their heels and keep them there, even to this day.
Yeah. So the AG has appealed that consolidation order. So essentially she's trying to get the case. She's still trying to get the case moved to Manhattan. Is that
right?
Yeah.
Yes. And again, we don't see it, and obviously I agree with my own side. We help write the papers and deal with that. But I just think it's a frivolous appeal. But you know what? We go through that process, and at least during that time, they're not harassing our pregnancy centers further, at least to some extent. It's still, you never like having that hanging over you, but this was part of the reason. We took that opportunity, that little, this little period here, to now look at countersuits. So the pregnancy centers that have actually directly been impacted by these attorneys general, they can't go to federal court, because you're sitting there going, well, wait, if this is a First Amendment issue, why aren't you in federal court? Well, state courts can litigate First Amendment issues, and when you're on defense, you can't get to federal court as a defendant normally. But because of every other pregnancy center in the state of California and everybody else in the state of New York is at risk. I mean, look, Letitia James is picking like a tiny pregnancy centers that are pretty much just doing diapers and wipes, and just, it's a volunteer manning a phone line. If she's going to pick them off, up to the biggest pregnancy centers in New York, everybody's at risk. And so we had the idea we need to go and do a countersuit in federal court, both in California and one in New York, to seek a federal court's decree that, yes, this does violate the First Amendment. And so we've done that both in California and New York. The one in New York, we had filed a case. Our colleagues over at ADF filed another case. We're in front of the same judge, and so we were able, that judge also, we got the facts in front of them. On APR, we are just so rock solid with all of the studies and you've got actual babies, and a lot of them, and so that is something that you can't ignore that as a jurist. So that is something that we're able to put in front of the court. So it's great to be right on the law, but when you're right on the law and the facts, my goodness, the door's open. So we were able to get, a preliminary injunction there. That's going up to the Second Circuit. And hopefully, the ideal would be if we can get the Second Circuit, to win up there on this point that, hey, it goes back to that fundamental point I had said earlier, that government cannot tell you what is true or false on an issue of significant public concern like this one. Although, frankly, if the government is determining who is true or false, we're right. Our view is true. Supplemental progesterone is a well-regarded, long-standing treatment for women who are at serious risk of miscarriage. And if you've taken the first abortion pill, you are extremely serious risk of miscarriage. So again, we've got both the law and the facts, but we'd love to we're hopeful if we can get out of the Second Circuit a good, strong ruling that, hey, First Amendment says government, get out. And look, we've just come through a contentious election cycle where there's fake news and misinformation, disinformation. We had the COVID focused the country on, elements of, well, the government declared this was true and they threw people off of social media if they didn't agree with the government's line. Well, then all of a sudden, a year or two later, we realized, well, actually, the government was wrong. And it turns out the people that got kicked off of social media were right. Maybe they weren't fully right, but they were right a lot of the time. And so that whole topic and this idea that the government cannot declare what's true or false on an issue of significant public concern, that is something we think needs to be, we need that in more court decisions. I can say it, we know it's true, but you needed judges to agree to it and really, ram it home so that we won't be facing, ideally, we get some good ruling out of the Second Circuit. Out in California, we're fighting out there, and that's still in the trial court right now. If we can get some courts more courts to come with us on that point, then hopefully this latest round of abusive litigation by attorneys general can be put to bed, and just so that the pregnancy centers of the country can just do their work. My goodness, we've got a lot of work to do. The abortion rate's going back up, so there is a great need for pregnancy centers.
So if those federal cases are resolved in favor of the pregnancy centers, what does that mean for the state cases?
Well, so this is a fun issue of federalism and comedy between courts. So once, unfortunately or fortunately, when the attorney general is coming after you, when they've got you in court and got you in state court, you're pretty much stuck. You're going to go through that process. But if the Second Circuit, if the United States Court of Appeals for the Second Circuit says, no, that violates the First Amendment, well, I think, state court system is going to be tough. They're going to be hard pressed to go, oh, no, this is just fine. We're going to come after you, and we're going to come after you great guns. If the Ninth Circuit Court of Appeals says that, is the state of California attorney general going to proceed in state court against us in this way when that same person, that same government official has actually been enjoined from doing it against a different party? So it is I mean, look, we're in a unique point in American history on a lot of grounds. But it's one of those legal issues that's it's not totally clear, but having a court say, hey, First Amendment protects this conduct and you need to back off. That is extremely helpful. We would call it persuasive authority, even if not binding authority from the legal side.
Right. So, Peter, earlier in the podcast, you referenced the NIFLA decision that went up to the Supreme Court, where California had targeted pregnancy centers and tried to put the thumb on the scale of what they had to say. But it sure seems that one was before Dobbs, but it sure seems like since Dobbs, pregnancy help centers have been in the crosshairs a lot more. Like we're really feeling the heat. Why do you think that is? Why do you think that pregnancy help organizations are being targeted? And do you think that's likely to continue?
Well, unfortunately, after Dobbs, we in our firm had to really look at it. We have more of a red state strategy and a blue state strategy, and red and blue on abortion. Really not. I mean, it does seem to correspond to a political party, but it's not necessarily political. And so in the blue states, the pro-abortion states are the ones that at least are electing pro-abortion elected officials. I mean, we are seeing double, triple time against our clients, whether it's on the sidewalk, whether they're at the pregnancy centers, just all over the place. And to some extent, in these states, they've fully legalized abortion pretty much up to the moment of birth. They're funding it. They're paying for people to fly in or drive in from out of state to engage in it. They're putting up public education campaigns in favor of it. And to some extent, they don't have any other way to show how pro-abortion they are. Next up is let's attack the pro-lifers directly. And of course, unfortunately, on the left, just generally in America, they have taken this censorship model, which we saw during COVID. We've seen, even during recent political campaigns, they've taken a censorship model and really rejected the First Amendment. When the left was always the pro-free speech side, they've become anti-free speech, even to the point of threatening to repeal it or undermine the First Amendment if I guess if the elections had gone differently in November. But as we look at it now, so they've got so that's the thing. They're less respectful of free speech. They are funded by these abortion industry folks and people that really care about the abortion industry. And so and there's really, they've done everything else they can do other than start attacking us directly. So that is what's coming in. I would say with the pregnancy centers also, I mean, they are an existential threat to big abortion. And the reason, one of the reasons is because pregnancy centers put the lie to the claim that, well, no one regrets their abortion. Oh, well, abortion's no big deal. Well, if it was no big deal and no one regretted it, well, then why do we have this network of 3,000 centers across the country? Why do we have such fervent support at the local level for our various pro-life pregnancy centers, where you can put 500 people in a banquet hall, on a Tuesday evening, and people are pulling out their checkbooks and they're, writing big checks, and doing baby drives at churches. And I mean, to me, to some extent, I mean, the pregnancy center it has become the hub for pro-life activity in most communities. And this is kind of a new thing, and I don't want to get off on that. Is a tangent. We can talk about, but maybe not today. That really, whereas you used to have county right to life, and you might still have your church right to life, you have a state right to life, and all that. We really organize more at the pregnancy centers. That's where most of the activity is coming, and you're even seeing now with greater cooperation between sidewalk counseling ministries and pregnancy centers. You're seeing more of that happening, that the more activist pro-life side is really unified with the pregnancy centers. And I think it's a beautiful thing. So, I mean, really, and the movement is focused where we are, right on the ground, helping women. And then specifically to APR, abortion pill reversal, that is this latest target. It doesn't just put the lie, so pregnancy centers generally put the lie to the abortion industry's claims. APR specifically goes after the abortion industry's new favorite way to abort a baby. So, I mean, now 60% more, really puts the lie to the chemical abortion regimen and shows thousands of women do not want the abortion, even after they've started it. So again, I mean, it is right there. It is in your face, and you've got live babies that you can look at and go, that is a reversed abortion. But there's also a danger, which is if that same woman, when she calls the abortion clinic to go, I don't want this to continue. So they've taken the first pill and I don't want it to continue. The abortion facility will say, well, there's nothing we can do for you, or you have to finish it out. You need to come in and take that second pill. Well, that sounds like medical malpractice to me. And my goodness, personal injury lawyers are by nature more liberal than conservative, and they're probably more pro-choice than pro-life on abortion. But, if there's money to be made, you got a lot of personal injury lawyers in this country, and that could cause a real problem for the abortion industry itself. So that's, all of these together, I think, give you the answer as to why they're targeting the pro-life pregnancy centers so intensely, and why they've chosen, something like abortion pill reversal as one of their targets.
Yeah, I'm reminded of the very first line of the complaint in California, where they open their argument by saying that abortion regret is exceedingly rare. It's just such an odd way to open the argument, I think, but it goes to show, it's like they showed their cards from the get-go. That's the issue that they have with APR, is abortion pill reversal shows how conflicted women are when they make that decision. It shows how ambivalent they are. The fact that they're not even all the way through the process and they already want to change their minds really puts the lie to, this is, a shout my abortion, I freely make this choice. And so I mean, I think you're absolutely right. Peter, as we're wrapping up here, do you have any advice or encouragement? And I'll say just more broadly for pregnancy help centers, and then also for how they approach APR in light of the fact that it's so attacked.
Well, so generally to pregnancy centers, I will say this. So we've kind of talked about pregnancy centers becoming the new hub of the pro-life movement. But where pregnancy centers before, and when I started mine, which is now we're coming up on 20 years ago, the idea was keep your head down, let the activists and the politicians and everybody else, they'll be the public face of the pro-life movement. You just do your work and stay quiet. Well, with the new roles, you don't have that option anymore. And so for many centers, so for instance, I've had instances and, recently we found out that, a center got a subpoena from a state AG, and they just answered it. They didn't even call us. And I'm going, and now all of a sudden, there are side, issues to be dealt with. So, folks are not necessarily used to being in the limelight, not necessarily used to dealing with these issues. So please know that you've got resources, folks that you can call and immediately get help. So here, whether it's us at Thomas More Society or the other fine, public interest law firms out there. But I would say this, my standard advice, it's don't panic. It's from Douglas Adams' books, The Hitchhiker's Guide to the Galaxy, I think was if you're my vintage, that's what we read when we were little or younger. Look, the legal process is confusing. It is difficult. It can be very burdensome, but you have allies and friends who will take you through it. But don't worry about it. Don't panic about it. I'll tell you too, when we were fighting the Illinois fight, one of the issues, so I mean, I think that the pro-life movement handled it spectacularly in the state of Illinois, but there was a subset of pregnancy center directors who started to actually change their practices based on what they thought the law would do before the thing was even signed. And I'm going, what are you doing? No, don't do that. Be proud of what you're doing. Now, I did say, I said, look, if you think you're doing something deceptive, well, stop, because that would be sinful. I don't care about the law. That would be improper. You shouldn't do that. But it wasn't that. They were just afraid. It wasn't they were doing anything wrong. It's that Kwame Raoul, the Attorney General of the state of Illinois, would think they were doing something wrong. Well, let's not live like that. Let's not live in fear. And so those are some of the advice I might give. And it doesn't mean you have to be the tip of the spear. You've got to be out there. But I would say I have found that the supporters and donors for pregnancy centers that have been attacked and that have responded strongly, that all of a sudden, your support base appreciates that now a lot more than they used to. So I might say, stepping into that, it doesn't necessarily mean, walking into the roar, but, getting a little more, into that and being a little feisty at times has been rewarded. From what I can tell, it has not been punished by our friends and supporters.
Yeah, and I think a big change in the last couple of decades is that we now have organizations like Thomas More Society with great attorneys who are ready and willing and, dare I say, eager to step into the fray and defend pregnancy help. So thank you for giving pregnancy help organizations that comfort of knowing that you're there for when they get that subpoena in the mail or that call from the reporter asking them to comment on the lawsuit that they're eventually going to receive, apparently.
Well, I mean, look, remember, most of the centers are not getting targeted, but at the same time, if you have been blessed with that opportunity to be targeted, we will help you respond vigorously and in a way that makes the most sense, that will help your ministry, to continue to thrive. Because usually too, look, they wouldn't be coming after you if you weren't over the target. I mean, you guys, Heartbeat and all of the centers, you're being incredibly effective, and that's why you're being targeted.
All right. Well, thank you, Danielle and Peter. I appreciate both of your time with us today. Peter, it's so good to know that with your background in pregnancy help, you and the team at the Thomas More Society just have such a good understanding of pregnancy help, and that you guys are the ones fighting those legal battles. So thank you again for all that you're doing. And we're anxious to hear what happens with all of these cases as we move forward. So with that, I want to remind our listeners, subscribe to this podcast because we'll continue those updates. And with that, I want to thank all of our listeners for joining us for this episode of the Pregnancy Help Podcast.